All right, so I guess I'll start with the meeting, right? No announcements. Good afternoon, everyone. My name is Georgina Lepe. I'm the attorney, and today we're gonna go over the benefits of having a living trust. Let me share, put it in PowerPoint. So here we are. If you have any questions, please wait until the very end to submit them in the chat section. I'll take your questions then. Either if you want to unmute yourself or to type in your questions. A little bit about my office. If you have not attended my presentations, I focus on estate planning, and that's what we're going to discuss today, the benefits of having a trust, the purpose of a pour-over will, financial power of attorney, advanced healthcare directive, and the list goes on. I also handle probate and real estate litigation. All right, so today's agenda. First and foremost, we're going to go over some key terms because when I'm discussing certain things, I want to make sure that we're all on the same page and I don't lose any of you. Then we're going to go over estate planning options. In this portion, I go over the 3 options that I tell all of my clients when they come into my office in need of estate planning. I'm also going to go over the downfall of adding children on title to your property. A lot of my clients, when they come into my office for their estate plan, they'll tell me, you know what, Georgina, instead of wasting money on an estate plan, I'm just going to add my children on title as joint tenants. That is the worst thing that anyone can do. And I'll go over the reasons why. The downfall of taking title as joint tenants. And then, like I said, at the very end, I will be taking your questions. So key terms. Throughout this presentation, when I'm referring to your assets, I'm talking about your home, for example, your primary residence, your investment properties that you rent, bank accounts, business interests, whether you have an LLC, an S corporation, or it's a sole proprietorship, timeshares, investment accounts, all that good stuff, even your vehicles. What is a will? I'm sure most of you have heard this word before. A will is a very simple document. It can be anywhere from 2 to 5 pages. And in that will, you identify yourself. You say, I'm a single woman, I'm a married woman, I'm married, these are my children, this is the name of my spouse. When I pass away, this is the individual that I want to be in charge of my probate proceeding, and this is how I want the judge to distribute my assets. There are different types of wills. There's a statutory will that is witnessed by 2 individuals, and that normally is typed. There's a holographic will where you literally grab a pen and you type the term, you handwrite the terms of your will. So just know that there's those options. So what is probate? Probate is the court supervised process that gets initiated when a person passes away with or without a will. This is one of the biggest misconceptions. A lot of people think that because they have a will, they're not going to go through probate, and that is not the case. If I think I'm gonna have to mute you guys because I keep hearing some background noise. Am I gonna be able to do this? Okay. So I'm muting everyone, sorry. So if you pass away with the will, you still have to go through probate because the judge has to make the determination that it is a valid will and that it was executed in compliance with the probate code. This also gives opportunity to anyone that wants to object to the will to present an objection in court. And obviously, if someone passes away without a will, you still have to go through probate. You as realtors have probably encountered situations where a potential client tells you, my mom or my dad passed away, I want to sell the home, but don't worry, they left the will and I'm the executor. Okay, well, that's great. Now you have to initiate probate. A lot of people think that with a will, you don't have to go through probate, and you do have to go through probate. What is a living trust? A living trust is basically an agreement. It's a set of instructions. A living trust is an agreement that either a single person or a married couple create during their lifetime. In this agreement, the person creating the trust is called the grantor or the trustor. And while they're during their lifetime, they are actually also the trustee. A trustee is a person that is in charge of a trust. So with my trust, I am the grantor because I created the trust, and I'm also the trustee because I'm still alive and I have capacity. So I am the one that's able to manage all of my assets that are in the name of my trust. You as realtors may be dealing with successor trustees, those individuals that are appointed by their parents to administer the trust upon the parents' disability or passing. So if you are dealing with a successor trustee, you want to make sure you get a copy of that trust to make sure that you're dealing with the correct individuals. So now we're starting with the options. So pay attention, everyone. When someone comes into my office and they say, Georgina, I want to plan for the future. I want to make sure that my children are protected, that my assets go to the correct individuals, I always tell them that they have three options when it comes to planning. Option number one is you don't do anything. You don't have a trust. You don't have a will. You have absolutely nothing in writing. At the end of the day, title controls. And people have this huge issue with this, but it is what it is. I'll give you an example. If you bought an investment property with a sibling and you took title as joint tenants, upon your passing, that property automatically goes to the surviving joint tenant because you decided to take title as joint tenants with the right of survivorship. In that case, probate is not opened. Your beneficiaries, your children, do not receive a dime of that house because pursuant to the vesting, it goes to the surviving joint owner. If you have any accounts, any financial accounts, and they list a beneficiary, upon your passing, obviously those assets would go to the beneficiary listed. But what if you and your spouse or you as a single person pass away and you're the only one on title to your property? Well, then of course, probate needs to get initiated. The problem with this option is that you have nothing in writing. You have left zero instructions to the judge. So the judge is going to distribute your assets pursuant to the probate code. That may include individuals that you do not have a relationship with, nor have you spoken to in many years. I'll give you an example. I met with a client last week and we were going over her financial accounts. So I asked her, I said, do you have any beneficiaries on your accounts? She said, no, she's not married and she doesn't have any kids. So I told her, if you do not plan, if you don't have beneficiaries on those accounts, or if you don't have a will, upon that your passing, all the monies that you have in your financial accounts, that money is going to go to your heirs at law. In your case, your heirs at law are your mom and your dad, and you haven't spoken to your dad in 20 years. But guess what? He's your heir at law because you have failed to plan. So if you pass away next week, your mom's going to have to share that money with your dad. So obviously she did not like that because dad has not been in the picture. Dad has not provided nor cared for her for all these years. So I'm assuming that as soon as she left my office, she ran to the bank. So this is what I always tell people. You need to make a list of all your assets. And obviously, if there's no beneficiaries or your house is not titled in the name of the trust, you're going to probate. And in this option, you have no instructions as to how the judge is going to distribute your assets. So it may go to someone that you have no relationship with. The downfall with probate is that it's very costly and time consuming. Probate can take about 2 years. That's assuming we move it super fast. And this means that none of the heirs at law receive a dime until the judge signs the order for final distribution. So it's going to be a while until these adult children receive their inheritance. Also with probate, we as attorneys get paid a percentage of the value of the estate. We're looking at the market value of the house, not necessarily excuse me, how much there is in equity, the market value. So if the house is worth 500,000, the attorney is going to receive at least 15,000. The family member that assists the attorney with the probate and serves as the personal representative is entitled to the same amount. So 15 plus 15, that's $30,000 on top of all the court costs. And also with probate, it opens the door to creditors, including Medi-Cal, the Franchise Tax Board, and basically anyone out there. Because when we initiate probate, we publish it in a newspaper. Once the client gets appointed as a personal representative, we have to send out notices to the Franchise Tax Board, Medi-Cal, and to any known creditor. So that's option number one. You don't have anything in writing, title controls, your heirs at law will receive your assets. Option number two, you have a will. You went to an attorney, you went to LegalZoom, you went online and you created a will. The good thing about a will is that you're giving instructions to the judge as to how you want your assets to be distributed. The downfall is you're going through probate. Also in that will, you're nominating an executor. You're telling the judge who you want to be in charge of the probate proceeding, but still you're going through probate. Be very cautious with having a will. A will only comes into play if probate is initiated. And like I mentioned earlier, not in all cases is probate needed, because first we have to look at vesting. How is title taken? So I'll give you an example. Let's say you you married someone and you bought a house as joint tenants. However, you have no joint kids together. You actually have 2 kids from a previous relationship, and your husband or wife has 2 kids from a previous relationship, but you have no joint kids. You thought to yourself, well, let me prepare a will to make sure that when I pass away, my 50% of the house goes to my children. So you go on LegalZoom, you create your will, and you say, I want my 50% of my primary residence to go to my children upon my passing. Well, guess what? You took title as joint tenants with the right of survivorship, whereas husband and wife as community property, or husband and wife with the right of survivorship. In that case, the house is going to go automatically to your surviving spouse, and your will does not even come into play because probate is not necessary. There's a surviving owner that's already on title to that property. So with the will, you're just telling the judge who you want appointed as executor and how you want your assets to be distributed. You still have to go through the entire probate process, which lasts about 2 years, and pay an attorney the statutory fee. Here I kind of broke down the fees for different values of estates. Obviously, if the house is worth more or there are several assets in a probate proceeding, the fees just go up. So this is the attorney's fees right here. And on the right, that's the personal representative fees. We as attorneys have the right to ask the judge to increase our fees. For example, if in the probate case, we had to sell a home or maybe a couple of properties, then we can ask the judge, you know, Your Honor, we spent X amount of hours working on this file pertaining to the sale of the properties. So we want our statutory fee to be increased, and that's very likely, it's almost always granted. In my cases, when I deal with probates and we have several properties going into probate, I always ask for my fee to be increased because I'm dealing with the trustee. I'm working to stop the foreclosure. We're working against deadlines. So it gets stressful. So 100% of the time, I ask for my statutory fee to be increased as other attorneys do as well. As a reminder, these fees do not include the claims, court costs, or any other costs associated with probate. So as you can see, if you just have one home and that one home is worth 500,000, when I say you just have one home, I'm not talking about, I'm saying you don't have any bank accounts, vehicles that are going through probate, then the attorney is going to charge at least 13,000. But imagine you have your home, you have your vehicle, you have financial accounts, then the number just goes up. This is a breakdown of the fees that are incurred in a probate and a trust sale. So on the middle column, this is if we were to sell a home in a probate proceeding. And on the right side is if we were to sell a house within a trust. So everything is the same, except that with a probate sale, you have the attorney and the personal representative fees, which is at least $26,000. And then you have estimated probate fees. So as you can see, there's about a $30,000 spread. That's assuming that the estate is worth $500,000, which is a very easy threshold to meet in the state of California, or should I say Southern California. I think any house is worth 500,000. Doesn't matter how small it is or where it's located. So I think nowadays we're kind of looking at the, higher end, either 800 or $1 million for a small estate where you just have one house. So option 3 is having a living trust. Like I mentioned earlier, a living trust is an agreement that you create during your lifetime. It's a set of instructions that you leave your successor trustee as to how you want your assets to be distributed. With a living trust, you can control your assets while you're alive and able to do so. When we prepare your living trust, the set of instructions, we also have to transfer all the assets into the name of the trust. If it's a property, we do this with a grant deed. If it's a financial account, you go into the bank to change the account owner to the name of the trust, and so on. So while you're alive, you're in complete control. So even if you transferred your assets into the name of the trust, you have the ability to sell your assets. You have the ability to do a reverse mortgage, home equity line, refinance. You can do as you please. If you want to deplete all your assets during your lifetime and not leave anything for your children, you can do that. So you are in complete control. You can also take care of yourself and loved ones if you become disabled. A living trust protects you in the event of a disability. So if you're unable to manage your financial affairs, your successor trustee steps in your shoes at that time and is able to provide for your care. For example, let's say that you're in the middle of refinancing your home and you lost capacity. In that situation, your successor trustee steps in your shoes and is able to continue with the refinance at that time, or if you were selling. You can give away your assets to certain individuals with your own restrictions. Like I mentioned earlier, if you were to die without a will, then a judge is going to determine who your heirs at law are. With a living trust, you can determine what percentage you want to go to certain individuals. If you want to disinherit someone, let's say one of your beneficiaries is a special needs child, then within the trust, we would have to create a special needs trust, indicating that that child who's a special needs trust wouldn't lose their government assistance, because we've created a special needs trust within your trust. Without unnecessary cost or undue delay, only if your trust is properly drafted and properly funded will you avoid probate. A lot of people believe that since they have a trust and all their assets are listed in their trust, that they're going to avoid probate. That's not the case. The only way to avoid probate is you need to have the living trust agreement with the instructions, obviously, and all your assets need to be transferred into the name of the trust. How do we do that? If it's your primary residence or rental properties, we prepare a grant deed where you transfer your ownership interest into the name of the trust. If you have an LLC, we do an assignment of interest. If you have a corporation, the stock certificate should be issued in the name of the trust. Your checking and savings account should be in the name of the trust. If you have a sole proprietorship, again, it's an assignment of interest. So everything needs to get poured back into the trust. So at the time of your passing, title needs to reflect the name of the trust. A lot of the times, these assets fall out of the name of the trust through a refinance, reverse mortgage, and so on. So I always tell my clients, when I create their trust, I tell them, call my office. I'll do a quick title check, because at the end of the day, I want to make sure that what they paid me, the work that I did, the time and effort that was made to create this trust, that it's not in vain. Because like I said, if you have a trust and your assets are not titled in the name of the trust, you are going to go through probate. So why do I need a living trust versus a will? A living trust avoids a costly and lengthy probate process. A will is a golden ticket to probate. A living trust protects you in the event of a disability. Like I mentioned earlier, if you are unable to manage your financial affairs, then your successor trustee steps in your shoes. A will does not plan for disability because it does not become effective until you pass away and the judge admits it into the probate proceeding. With a living trust, Medi-Cal liens are avoided. With a will, Medi-Cal will file a claim against your estate if you have received Medi-Cal benefits. With a living trust, blended families are protected, and this is a big one. Nowadays, it's very common to have children from different relationships that make, part of your family unit. So and it goes back to the same example I gave you earlier. If you and your current spouse take title as joint tenants, as husband and wife, you are disinheriting your children from your previous relationships, because probate will not be necessary upon your passing. Your assets will go automatically to your surviving spouse, and your surviving spouse has no legal obligation to share any of those assets with the adult children. On the other hand, with a trust, we're able to plan. We're able to include instructions as to what is going to happen in the event if one of you passes away. Are we giving the children a specific distribution at that time? How are we going to safeguard their inheritance so that they're not disinherited down the road? And with a will, children from blended families could be disinherited, especially if you take title as joint tenants or it has a survivorship provision in it. How about adding your children to title to your property? I always get asked this, Georgina, you know what? I'm just going to add my oldest child on title to my property. That way, when we all pass away, he'll be the surviving joint tenant, and then he'll know exactly what to do. Well, that's assuming that your child is going to survive you. That's assuming that you're never going to have a falling out with your child. That's assuming that your children do not get into an argument down the road and stop talking to each other. And now that your child is on title, any of his creditors can come after that property. Your child can actually get mad at you and file partition action to force the sale of that property because you decided to add your child on title. So now they're an owner of that property. If you ever want to refinance or do a reverse mortgage, then they would have to cooperate, because in the reverse mortgage situation, they would have to come off title. And if you're refinancing, if they have any liens against them, then those will need to get paid off. Also, it's better to inherit a property because the value of the property gets determined at the time of your passing. So there's a step up in basis, as opposed to you adding your children on title to the property during your lifetime. If you do that, then they inherit your tax basis. So at the time of sale, they're going to have to pay capital gains taxes, which is anywhere from 30 to 40% combined for federal and state. And by adding your children on title to your property, you lose control of your property. This is just a scenario so you can see how much someone would pay in capital gains taxes. Obviously, I went with a higher number of 40%. Parents purchased a property in 1986 for $250,000. The parents add the children on title. Parents passed away in 2040. By that time, the house is worth $700,000. The children sell the property, so their gain is about 450,000, and they would have to pay about 180,000 in capital gains taxes. Obviously, they can do a 1031 exchange if that's what they want to do. On the other hand, if you inherit the property and you turn around and sell it right away, there's not going to be any gain. Downfall of taking title as joint tenants. We do not live in a perfect world. We don't know when our time will come. I've had clients that'll say, you know what, Georgina, we're not going to spend money on a trust. We'll just wait for one of us to pass away, and then the surviving joint tenant can create a trust then. The problem with that is you're assuming that the surviving joint tenant is going to have capacity to create a trust. I turn away a ton of clients that come into my office wanting to do a trust. Well, it's not them, it's their children that bring them, but parents don't have capacity. I am not going to put my license on the line to prepare a trust for someone that does not have capacity. The capacity required to prepare a trust, it's much higher than that to execute a will. In order to sign a trust, you need to understand the legal implications of a contract, because that's what a trust is. It's a contract. So for those individuals that wait a little bit too long to create the trust, you're going to find some attorneys will not prepare it. I know with me, I am very strict with that. If I have any inclination to believe that a person lacks capacity, I'm not going to take on that risk. Other attorneys do, I don't. So just keep that in mind. Don't wait too long to create your trust. Downfall of taking title as joint tenants. Blended families are not protected. Individuals do not understand the legal implications of taking title as joint tenants. If you have any investment properties with someone that's not your spouse, go on title. How do you hold title? You'll be surprised that it's quite likely that you hold title as joint tenants and you had no idea. And like I mentioned, what this means is you pass away and the property goes to the surviving joint tenant. Adding children on title will cause issues. So what's included in the estate planning portfolio? You get the living trust agreement. That is where we indicate who the successor trustees are going to be. How are the assets going to be distributed? Are there going to be any restrictions on the distributions? We also give you a pour over will. And everyone always asks me, well, Georgina, why are you giving me a pour over will if I'm creating this trust? Isn't trust supposed to avoid probate? Well, yeah, if everything is managed properly and titled properly during your lifetime. But if an asset is not titled in the name of the trust and it does not have a beneficiary designation, we're going to need to go through probate. So you need the pour over will to instruct the judge to transfer that asset back into the trust. The second most important document that you will be signing is the financial power of attorney. The financial power of attorney avoids the need of a conservatorship of the estate. With this document, you're nominating someone to make financial decisions for you if you lack capacity. What type of financial decisions? Anything that deals with your assets that are not titled in the name of the trust. What if your house, your vehicle needs to be sold? You know, vehicles, we don't transfer those into the name of the trust. So that needs to be sold. Your agent under the financial power of attorney can sell that. If you get sued and you lack capacity, your agent will be able to hire an attorney or show up in court on your behalf. Communicating with Social Security, going to the post office to pick up any mail that needs to be signed off on, communicating with credit card companies, memberships, all that good stuff. So my financial power of attorney is about 25 pages. We also include an advanced healthcare directive, who's going to have the ability to make financial decisions for you if you're unable to make them. There's other property documents included, deeds, and a lot more. It's a big binder that we create. These are the prices. Give me 1 second. Okay, so these are the pricing, all those documents that I mentioned, with one home and the notary fee, the recording fees, $17.49 for a single person, and for a married couple, $2,599, and for each additional property, it's $300, since we have to record and prepare that deed. All right, so I'll open it up for questions now. I see some people wrote some questions in the chat. Do you take any eviction cases? No, I am no longer handling evictions. I used to, but I am super busy with my civil litigation cases, probate and trust, that no more evictions. How valid is a handwritten will without a witness? It's valid. As long as the handwritten will is in the decedent's handwriting, it's valid. Obviously, someone may contest it and say, well, that's not his or her handwriting. But actually, right now, I have 3 probate cases with a handwritten will. When distributing property to the beneficiary, when the grantor is still alive, I'm not going to answer any tax questions regarding gifts, so sorry about that. Medi-Cal liens are avoided. So with the trust, you avoid Medi-Cal claims. Whether you as an individual qualify for Medi-Cal is not affected whether or not you have a trust. So whatever you have in the trust, it's as if you owned it outright. So if you don't qualify without a trust, you're not going to qualify with a trust, if that makes sense. All right, so does anyone have any questions? I don't know if you can unmute yourself now if you have a question, or you want me to unmute you. Jack, do you help foreign national customers as well? No, I do not, sorry. Does the fee increase add with other type of assets? No. So with other type of assets, you yourself would be funding those into your trust. So with your financial accounts, you would go into the bank to transfer those into the name of the trust. Any other questions? Anyone want me to unmute them? No, I think so. I think that's it, right? No other questions? All right, everyone. Thanks for joining me today, and I'll see you at my next presentation. Have a great day. Bye.